Hi, I'm Erin, and I'm an estate planning lawyer and the founder of Nobles Law. I founded the firm that would become Nobles Law in 2017 after spending years as a trial lawyer, where I saw firsthand the consequences of families who failed to plan their estate or who had an estate plan in place that they thought was adequate but didn't end up being sufficient for them. Unfortunately, this often meant families ending up in conflict and in court, arguing about who was going to take guardianship of minor children left behind when their parents had passed away, and arguing about the assets that were in the estate. So when I decided to start my own practice, I wanted to focus on making sure that my clients had the peace of mind from knowing that that was never going to happen to them and it was never going to happen to the people that they love. At Nobles Law, we focus on estate planning with a particular emphasis on the needs of families with children under 18 or children who are young adults. But even if that's not you, I think you're going to get a lot of value from tonight's webinar, 10 Steps to Plan Your Estate in 2023. Okay, so as we get started, I am going to save the questions for the end. If you are not comfortable asking questions in the chat, you can always reach out to me by email at info@nobleslaw.org, or you can call our office at 781-317-5882. Remember that questions that you put into chat are not attorney-client protected. And although I am an attorney, I'm not yet your attorney. So information that I talk about tonight, or even things that I talk about in response to questions, should not be considered specific legal advice, but just more general and informational. At the end of the webinar, I am going to tell you a little bit about how you can schedule a meeting with me or with my team, and I'm going to give you a very valuable gift just for attending the webinar tonight. And just to let you know that we are based in Melrose, Massachusetts, which is on the North Shore, but we do see clients virtually throughout the Commonwealth. All right, well, let's get started with the 10 steps to plan your estate. These are 10 things that you can do right now before you even schedule your appointment with me. All right, the first step is set a deadline. And I think that this is the most important step because I found that once you set a deadline and actually put it on your calendar, you're more likely to actually get it done. So this doesn't have to be carved in stone. Obviously, situations can change and you may not be able to do it by the deadline, but it's a goal. So go ahead right now and open up your calendars, open up your phone, and set a date 6 months from now. Maybe say by the time your birthday rolls around in August, you're going to have this done. And then give yourself sufficient time to actually go through the process. And I'm going to say that that takes about 6 to 8 weeks, plus build in, a couple of weeks to actually find some time that you can schedule that appointment. So go ahead and do that. Set your deadline, and let's get started. Step number 2 is educate yourself. Now, as I said before, we work a lot with young parents. So I work a lot with people who are doing their estate plan for the first time. Education is a huge component of what I do. But I always think that people feel a little bit more comfortable when they have done some research on their own. Maybe about what a basic estate plan looks like, some things you need to think about, what some of the terminology that the attorney is going to use when you meet with them. Knowing that in advance will, I think, give you a comfort level because you know what to expect and you're familiar with the things that are being discussed in the my website has we have a blog on my website, so I'm oftentimes sharing information about estate planning, various issues related to estate planning on that blog. That's nobleslaw.org. Another good resource is the Personal Family Lawyer, which is personalfamilylawyer.com. planningyourstate.com. That's got all sorts of information, again, about the process of planning your estate, and it's a good place to start. Step 3, get organized. So clients tell me that for them, this is the best part of working with my firm, because I really put an emphasis on understanding what you own and what's going to happen to it. But you can go, and I really help you by putting together a spreadsheet that contains all sorts of information about your assets, and how they're owned and how they're going to be distributed. But you can get started in advance of meeting with me or meeting with your lawyer and create that personal balance sheet where you're listing out all your assets, their values, and any debts against them. So for example, you might go on to Zillow or Redfin and get a general idea of what fair market value might be for your home. And then pull out your mortgage statement and find out what's due on your mortgage. Subtracting the fair market value from what's due on your mortgage gives you a general idea of the equity that you have in the house. And that's an asset that you're going to be passing on. So you're going to want to do the same thing with respect to your bank accounts. So get a recent statement, your 401k, your IRA. If you have a financial advisor, talk to him or her and see if they can put together a report for you. You're also going to want information about policies of life insurance that you have. Now your lawyer is going to want to see all of that. So going ahead and starting to get some of that information in advance can really help you out and certainly save some time once you've scheduled that appointment. Step 4, make a list of beneficiaries. Now, your beneficiaries are pretty much exactly what it sounds like. They're the people who are going to get the benefit of your assets. And if you have minor children, it's pretty clear who your beneficiaries would be. Your surviving spouse, if you have a surviving spouse, and then of course your children. But maybe you have nieces and nephews, maybe you have charities that you're interested in assets to. You're going to want to start gathering that information together because that's something that your lawyer is going to want to know, is going to need to know to put that into your plan. So complete names, dates of birth, and contact information, address, email address, and phone number is a good place to get started. Don't worry about making an exhaustive list, but just get started gathering that information. And once you've done that, step 5 is do some thinking about how your beneficiaries should receive their inheritance from you. Now, of course, you have a lot of options with planning. You can decide to distribute your assets all at once. You can distribute them slowly over a period of time, or you can even hold them in trust for an indefinite period if you want to be able to put some more restrictions on your inheritance, which also usually has the benefit of protecting the beneficiary from creditors, from predators, and maybe even reducing taxes that are due. Step 6, choose your representatives. So your representatives are those people who are going to have to come forward and step into your shoes, either during your lifetime if you become incapacitated or when you pass away. And your lawyer is absolutely going to ask you who you want in those different roles. So do some thinking about who you might want that to be, who you would want making financial decisions during your lifetime as your financial power of attorney, and after you pass as the personal representative of your will or a trustee of your trust. Now, again, this doesn't have to be carved in stone. You're just thinking about this right now and trying to get a sense of who you think those people should be. Like your beneficiaries, you're going to want to make sure that you've got their complete name, information about their address, information about where they live, their phone number, their email address, and then other things such as whether or not they're a U.S. citizen, because in certain roles there could be complications from naming a non-U.S. citizen as your representative. Oftentimes your lawyer can help you work through that, but it's important that they know that at the outset. Step 7, spend some time thinking about end-of-life decision-making. And unfortunately, I think that this is an area that sometimes gets a little bit less attention in estate planning because we're talking about financial issues, we're talking about your assets, we're going through a lot of complicated conversations. But it's really important that you think about how you would like decisions to be made at the end of your own life, because that's going to be part of your estate plan as well. In Massachusetts, you choose someone to make decisions for you. That's your healthcare proxy. And you may provide them some sort of a guiding statement as to the kind of treatments you would want and you wouldn't want. But primarily, from a legal perspective, your proxy is the one making decisions. So you're also going to want to think about who should be in that role. You want it to be somebody who understands and would respect your position about end-of-life care, even if it's difficult for them and even if it's different from what they would want done. And you're also going to want somebody who is able to manage conflict in case they get some challenges or pushbacks from members of your own family or perhaps the medical team. So if you bring some people if you bring the names of some people to the meeting with your attorney, that certainly can help expedite that process. Step 8, keep a log of questions. I really, really can't reiterate how important this is. I love it when I see clients come in with their tablet or with their notebook where they have a list of questions, because I know that they've written things down, they've been thinking about it, and they want to make sure that their issues get addressed. I don't know about you, but sometimes when I meet with my doctor, I have a list of questions in my head, but if I haven't written them down, when I'm in the exam room, I completely freeze up. And I know that that happens with lawyers too. So just bring in your log of questions. Your attorney should be ready, willing, and able to answer them for you. Step 9. Be kind to yourself. So estate planning lawyers talk about death and tragedy morning, noon, and night. So we have kind of become, I guess, a little bit numb. But I am very aware that this may be the first time that you've ever thought about your own mortality and what would happen if you weren't around anymore and you weren't able to take care of your children, or perhaps you were incapacitated and unable to care for yourself. So these are very heavy questions, and I know that they bring up a lot of feelings. So I would suggest that if this happens to you, be kind to yourself. Be aware. Don't berate yourself for being emotional or upset. It's fine. Take a break, and then we'll get started again. Step 10 has to do with the question that many prospective clients ask when they call me, and that is, how much is a will? Unfortunately for them, they get the most lawyerly answer possible, and that answer is, it depends. Do you want a boilerplate stack of documents that may or may not work when your family needs them? Or do you want to develop a relationship with an attorney who's going to get to know you, get to know your deeds, get to know your personal situation, and create a plan for you that makes sense now and that's going to work in the future? And not only that, but who's going to be there for you on an ongoing basis as your life changes, as you need to make amendments, as the law changes. And obviously, one of those is more expensive than the other. So I think it's important to really consider the value of what you're receiving and not just necessarily the price. But I do know that it's really hard to understand the value of estate planning. You've never done this before. And that's why we start every interaction with any potential client with what I like to call the family wealth planning session. So after you've had a chance to after you've watched this video, or if you still are not quite ready and you'd like to call and just chat with me a little bit, you can do that. But when you schedule your family wealth planning session, we will put a 2-hour meeting on the calendar where you will meet with me. We'll go over some paperwork that you've completed, and then based on that information and what you tell me in the meeting, I'm going to share with you exactly what would happen based on your assets, your family structure, what would happen if you were to pass away? And I think that's really important because until you see the consequence of not planning, what the status quo is, I think it's really important. It's really hard to know the type of planning that you'd like to do. And from there, we help you if you feel like what would happen is not okay, we help you put the most cost-effective plan into place. So we like to say that, you know, it's going to be the plan that is worth more to you than your loved ones would have to pay in the event of your death without planning. So as a thank you for coming to be here today, I would like to invite you to schedule a family wealth planning session with Nobles Law. And again, the family wealth planning session is not a consultation. It's a real opportunity to meet with a lawyer and to get clear on your assets and what the law actually says. This process will help you get more financially organized than you have ever been before, and it will help you make sure that your family has a plan that will work when they need it to. And again, as a thank you for being here today, I'd like to invite you to schedule this family wealth planning session at no charge. I usually charge $750 for this, but to thank you for being here today, and if you can commit to doing some homework, usually takes about 20 minutes to 30 minutes to do the homework, I can offer that to you at no charge. Additionally, I'm going to offer you an additional $250 off your planning for attending this webinar. So that's $1,000 value just for being here tonight to learn about something that you wanted to learn about anyway. So I call this the golden ticket, but I need you to go ahead and take some action so that you can make sure to get the benefit of that. So what I need you to do is email us at info@nobleslaw.org. You're going to want to put, I want my golden ticket in the subject line, and we'll send you a link to book your family wealth planning session online. You'll book it online, but you can always meet with us in person. If you're not quite ready to do that, or you have some questions that you're not going to be comfortable asking, and we're going to get to those in just a minute, you can go to www.nobleslaw.org or call us at the number listed here to schedule a free 15-minute consultation. If you decide that you'd like to move forward with the family wealth planning session, just mention that you have watched this video and tell me that you want your golden ticket, and we'll make sure that that you get the free family wealth planning session and the additional $250 off of the planning that you do with us. Okay, all right, so I'm gonna just check the chat to see if we have any questions. Okay, so somebody wants to know who can be the executor of a will. Okay, so that's kind of a general question. The executor, but you're on the right track. The executor of your will in Massachusetts, we call it the personal representative, but it's actually, I can answer this about any of the different roles of the representatives that are involved in your estate plan. You need to choose somebody who's over the age of 18. You want to have them not be a family member or somebody who is receiving anything, a beneficiary, under any of the things that perhaps you're distributing in your will or in your trust. People sometimes ask, well, do they need to live in Massachusetts? And the answer to that is probably not. It is 2023 after all, so it's not uncommon for a representative to live in another place. One caveat to that, I think, is that when you're choosing a guardian or a temporary guardian for your children in an emergency situation, you want somebody who would be able to step in almost immediately. So in those types of roles, you want to choose somebody who probably could be here in 20 to 45 minutes. But other than that, there's usually no issue with having your representatives live in another state. Okay, all right, so let me just take a look and see if there's anything else. Okay, so somebody wants to know if I would recommend a trust if they have minor children. So that's the type of question that is very, very individual. And when I do the family wealth planning session, I always feel that my job is to inform you as to what your options are so you can make an informed choice for yourself. Oftentimes with parents, we do create trust, but there are many, many ways to do that. So I would urge you, if you have questions about that, go to our website, call us to either schedule the free 15-minute consultation, or if you think you want to move forward with the family wealth planning session, schedule that meeting too, and I'll be able to give you a little bit more specific information. Okay, so I didn't see anything else in the chat. So on that note, I want to thank you all for attending our session tonight on the 10 things that you can do to get started planning your estate in 2023, even before you meet with a lawyer. I hope that you'll take advantage of our golden ticket and email me or call our office to schedule your session today. Thanks very much. I hope you have a happy holidays.